Good afternoon, good evening, ladies and gentlemen. Thank you very much for joining us this afternoon and this evening. On behalf of Baker and McKenzie and our International Trade and Commercial Group, I'd like to welcome you and thank you for joining us at the fifth session of our Global Trade Conference. As you can see from the slide up before you right now, the focus of our program in this particular session is on the so-called Russian countermeasures. For the discussion in this program, it is my great pleasure to introduce to you my friends and colleagues, Teresa Michaud, one of the litigation partners in our Baker McKenzie Los Angeles office, Vladimir Efremov, one of the partners in our Moscow office, and his colleague Alexander Korkin, also one of the attorneys in Russia, based in our St. Petersburg office. In the course of the next few minutes, we're going to talk about the various Russian countermeasures. I hope that many of you had the opportunity to join us for our panel several hours ago this morning, where we talked about the various sanctions that have been established or enacted by US, Canada, the UK, the European Union, and other countries. As we've been working with many of our clients in grappling with those sanctions, many of those companies have made determinations or maybe even been required to make determinations by virtue of the sanctions to scale back or withdraw from business operations in the Russian Federation and or Belarus. In doing so, a variety of problems and issues come up, however, under Russian law that have a direct and immediate impact on efforts to modify business operations in Russia, or even in some instances to continue status quo ante with respect to Russian operations. And that's what we'd like to talk with you about in the course of this particular session. Before we launch into the substantive discussions with Vladimir, Alexander, and Teresa, let me just attend to a couple of housekeeping matters. It is our objective to make this program and all of these sessions as helpful to all of you as we possibly can. I hope that you've all received copies of the materials so you can follow along with us as we talk about these points. If you have not, we will place a link to the materials in the chat, and you'll be able to download those materials both for following along in this session and as reference points. Correspondingly, at the conclusion of the whole set of sessions, we'll make available a link to the recordings of these programs. So if you want to use that as reference point, it will be available to you as well. And furthermore, with respect to making the program as beneficial as possible, we very much invite your questions and comments. Please use the Q&A function on the screen to pose your questions, and we will endeavor to address them at the conclusion of the session, time permitting. To the extent that time does not permit us to respond to all of the questions posed, we will endeavor to revert to you directly by email following the program with responses to your questions. So please do not be shy about posing questions about the points we speak about this afternoon. Our program has been approved for continuing legal education, CLE, CPE, CCS, and MEI, continuing legal education, or continuing education. With the materials that were distributed yesterday, there is a form by which you can claim that credit. We ask that you return the form to us within 72 hours of the end of the session so that we can be sure that you get the credit you need. Some of our team members are presenting remotely from home or otherwise, so please do indulge us. We'll try to minimize external distractions, but there could be a doorbell with the Federal Express or Amazon delivery, or a dog barking in the background or something of that kind. As I say, we'll try and minimize it, but please do forgive us if there is some kind of an interruption or distraction. Well, with all of that by way of introduction, let's proceed to our substantive discussion. You can see the agenda that we put up here. And to lead us through the first part of the agenda, let me turn it over to Vladimir Efremov. Vladimir?
Thank you so much, John. That's a real pleasure to participate in this conference for so many years and have a possibility to exchange your reviews and opinions and just outline the position and legal environment, what's happening here in Russia. In the introductory part, John has mentioned that indeed the companies, the businesses are looking how to reorganize its Russian presence and basically how to continue doing business with Russia, provided, of course, it's possible, subject to very well-known limitations, circumstances, and legal requirements. And at the very beginning of the crisis, the Russian Deputy Prime Minister, Andrei Belousov, made an announcement. And basically, it's still valid until the moment. And probably that's a very good message to start with. So he specifically commented, saying, well, we see that due to all those circumstances, the one I've just listed, the businesses going to either leave the market or somehow reorganize. We appreciate and we understand it. And the idea is that Russia would like to stay being, an open economy. However, he suggested in his speech, again, as I said, which was made at the very beginning of this crisis, that as he believes, there are several options available. And he specifically mentioned about 3 of those. So he mentioned it could be either sale of a company to its managers, and now this option is widely known on the market as MBO, managers buyout. Another option mentioned by Mr. Andrei Belousov was sale of a company to some independent investors, right? And the third one, of course, according to Mr. Belousov, was to stay in Russia and do business as was. And then, of course, because several months passed, we may, let's say, a little bit discuss on what's happening here on the ground and what we see the businesses are doing. Probably the sale of company to its managers became one of the most commonly met options for reorganizing of the business in Russia. Of course, due to a number of reasons and circumstances. First of all, just because the management is very well aware of the processes, of the standards. So the company itself knows relevant managers for a number of years, and a question of trust, of course, is very important here. But honestly speaking, there is another reason why this option is very, let's say, might be commonly met here in Russia, is the possibility to agree on a call option. Of course, we all are aware of all those type of limitations, including ban on new investments. And from legal technique, one, of course, clearly needs to pay attention how the call option itself should be structured and under which circumstances the call option could be realized. But of course, provided companies are considering a possibility at some point of time when the legal environment would basically allow to do so, they might prefer to buy the company back and then to continue doing business in Russia. And of course, it might be much more easier to agree on the call option with local managers and agree on the pricing. Of course, there are different pitfalls how that might be treated. I mean, the call option and its value from IFRS perspectives, for example, and lots of other aspects that will need to be taken into account. We see some of the companies are also exploring a possibility instead of just selling the company rather than to sell local assets. But here we need, of course, to take into account the complexity of different type of transactions. That's a classic, let's say, dilemma. What is easier, to sell a company or to sell assets? Please don't forget about the necessity to undergo special permission procedures and get clearances, for example, antitrust approval, where that is applicable. By the way, surprisingly, but last week, special interim measures were introduced, basically uplifting the value, the threshold, up to 2 billion rubles, which is approximately somewhere around 400,000 US. Oh, I'm very sorry. So 2 billion rubles should be more than this. So it's roughly 55 ruble per dollar right now. So then only in the excess of that newly established thresholds, there is a requirement to get a prior approval prior antitrust approval. Although in the past the threshold was lower, however, this interim measure is introduced until the end of the year. Clearly, I think the measure is to facilitate those ongoing exits and make it easier. We also see some companies are still considering a possibility of liquidating legal entities. Clearly, that's possible. However, it was announced that in case companies decide to leave the Russian market, they should close the business in full compliance with the existing procedures, meaning that all debts should be paid. There should be no indebtedness towards the tax authorities. There should be no pending litigations. As you can imagine, that significantly complicates the process of closing down the local entity, and it may, significantly, let's say, delay the moment when the legal entity would be officially closed. Moreover, liquidation of a legal entity must be necessarily, this is a requirement of the Russian law, must be necessarily accompanied with a mandatory tax audit, and tax authorities might be auditing the company for the last 3 years. And again, it's a question whether or not, there could be some sort of sins, and whether the tax authorities in the course of this mandatory liquidation audit might detect some of those underpayments. That's why some of the companies prefer to follow other option and keep the local entity dormant, hibernated. There is no corporate procedure for making the company dormant. However, effectively that means that the legal entity that doesn't perform any active sales and other type of operations, and only thing it is just doing, probably leasing the minimal required office space, paying salary to the single employee, which is a general director, and then submitting so-called zero tax returns, basically reporting that the organization is not engaged into business operations. This is what is called dormancy or hibernation, whatever you prefer. So that's why, like, some of the companies really follow that path. They keep, well, right now they wind down operations with the idea to keep the entity dormant. And again, the beauty of this option is that once the legal requirements in the US and other jurisdictions would be different from what we see right now, and there will be a possibility to resume operations, then there is already a corporate shell, no need to establish new legal entity, and then again, there are all chances to get back. Well, next, please. Next slide, please. Yeah, thank you. Well, we have new concept, basically a concept of unfriendly states. You may recall in the past, for political purposes, that there was a separate list. This is something we were discussing on one of our previous webinars, but it was existing only for political purposes. And there were just 2 countries there on the list. Surprisingly, Czech Republic, and less surprisingly, the United States. But now, starting from the beginning of the crisis, this is a new official category listing jurisdictions and countries imposing sanctions on Russia. And basically, as you can imagine, there are lots of such countries, not only the US, the EU, the UK, but also Japan, Australia, some other countries. And what effectively it means. Starting again from the very beginning of a crisis, the Russian authorities, and specifically the key role here is played by the president, started to introduce special measures. And when you will be going through those measures, then you will find that they predominantly hit the ability to perform business, some type of operations with counterparties located in unfriendly jurisdictions. The most commonly presented, let's say, example is a possibility for companies and individuals from unfriendly states, basically to sell real estate located in Russia. So those type of dealings are falling right away under the existing restrictions. A possibility to sell securities, Russian securities. And then there is, of course, a discussion what it means, security. And then you may ask me, okay, then how to comply with that plan suggested by Vice Prime Minister Belousov in terms of exit, if a foreign legal entity cannot sell securities, which means securities in legal entity. We have 2 mostly common type of forms of legal entities, LLCs and stock companies. And then equity and LLC is not viewed as security. That's basically selling equity and LLC would not be captured by this limitation. However, of course, sale of stocks, shares in joint stock companies would be basically limited, right? However, there is a possibility still to get a special permission of a governmental commission, right? So if a transaction is prohibited, then there is a possibility to get approval of a governmental commission. And I would say it's a very important thing that we have this governmental commission. It's responsible not only for granting permissions for these specific cases in terms of dealings with securities, but it's also entitled to give permissions for other restrictions in terms of currency control. For example, right now there are limitations on distribution of dividends to foreign legal entities from unfriendly states. There is a cap, 10 million rubles per month. The funds going in the excess of the threshold would need to be, deposited on a special account of so-called S-type. By the way, all type of those limitations, they're always accompanied with the necessity normally to transfer funds to special accounts, and they have different names. So S for loans and dividends. Then for those buying Russian gas, it will be a special other account. Payment of license fees, again, is limited, and all funds will need to be deposited by the Russian licensee on the account called O. So lots of specialists are basically guessing how the authorities are picking up those special names for those accounts. But well, honestly speaking, the answer is not found. And anyway, so as I have just explained, so when those funds for those specific transactions are deposited on those special accounts, there is still a chance to apply to the governmental commission and try to get a clearance. However, I would say, although it's not in the regulation, but there is a presumption of denial, and to get a clearance permission, there should be very valid and justifiable arguments why the Russian government should grant such a permission. Well, next slide, please. There are, of course, lots of other limitations, and as said, mainly of currency control nature. The individuals, for example, cannot withdraw hard currency from their local deposits. There is a limit, and that limitation is existing until mid-September. I think it will be extended. Basically, as all other limitations, they're valid until end of the year, so they could be extended as well. Another very important limitation is that individuals may transfer the funds to their foreign accounts within certain limits. Basically, now we clearly see a trend when the authorities are trying to relax rules, because, for example, this limit first was set as 5, then it was 10,000, then it was uplifted to 50, and now that is as high as $1 million per month. Basically, as you can see, the threshold is relatively high. And then, for example, yesterday, the Russian authorities uplifted another restriction because there was 30% limitation on advance payments related to services. So it was uplifted. Then there are no limitations for supply of goods, and then, as just mentioned, supply of services. And very important, companies and businessmen are really looking on the possibility to structure their shareholding structures and operations in a way that the shareholding structure is organized via friendly states. However, an important element here is that the ultimate beneficiary owner should be in Russia. That said, for those who are considering the possibility, for example, that still are present on the Russian market, to organize their shareholding structure in a way that shares will be held, for example, via a new hub, that is Dubai, I think, no surprise, or Turkey, or any other friendly jurisdiction. So that wouldn't really help, just because the ultimate beneficiary is located in a friendly jurisdiction. And this is something that will need to be checked by banks. And here we're coming to another very interesting part of our discussion, how to deal with the Russian banking system. Next slide, please. What complications basically we see here. And I would like first to stop and talk a little bit about the central bank. Of course, it's a matter of the US law. The prohibition on dealing with the central bank and this special general license that was extended until end of September. But I would like to underline the special role of the central bank, because the way a Russian system is organized, that all taxes, all fees, all type of state duties, they are payable on the accounts of the Federal Treasury, which are kept with the central bank. That said, in case the central bank will be recognized as a designated party, or the general license wouldn't be extended, then a huge question mark would be how to continue doing business in Russia, because then it will be completely impossible to make any payments to the Russian budget. And of course, this would immediately trigger relevant risks for individuals, right? For example, for non-payment of taxes, customs payments, and all type of aspects. Next slide, please. Of course, we see a lot of sanctions are being designated on Russian on Russian banks. More and more banks are becoming sanctioned. And by the way, due to this, recently the Russian government announced that they will no longer allow the foreign banks that are still present on the Russian market to leave the territory of Russia, to leave the market. So it remains to be seen how this will play out. But this announcement was made. And of course, for the business, a huge problem is how to identify those designated banks, how to identify from which accounts the counterparty basically will be paying, and what type of a strategy could be used to persuade to use, let's say, the bank accounts opened with neutral banks. And that's a separate, very, I would say, hot topic, because we see there is different reaction of different Russian counterparties. Some are refusing to do so. Some are referring to their legal obligation, for example, stipulated in relevant credit agreements to necessarily keep all accounts with the creditor bank. So there could be different complicated situations, but all in all, we see that the companies, they manage, let's say, manual regime, right? Very difficult to do that, in other way, but discuss that with each particular counterparty to persuade, to talk, and then agree on some amicable solution how this could be handled. But all in all, I think it's doable. And anyway, that's a very significant issue. So, and then if we will go to the next slide, please. What are the consequences, right? What is the complication? So if the counterparty is designated, if the party is not designated, but its bank is, then how to continue doing business with such counterparty? We also see other quite interesting complication that some of the employees of local companies, they might be holding their personal bank accounts with designated banks. And then the question is how to handle this matter. What might be done in this regard? And we see companies, of course, looking to which extent those alternative options won't be viewed as circumvention and it won't violate the applicable limitations. Of course, this is all valid and they must be taken into account. However, what we see, the companies are exploring in which situations the cash payment could be done. Again, we have to take here into account general compliance aspects. Whether there is a possibility to make assignment of that, right? Would it be allowed? Is it possible to have a letter of credit opened, let's say, with some other bank, so that the counterparty will go there and then it will be dealing with your bank, but at least the bank account opened with a toxic bank won't be an issue for you. And another option we see is right now often used, for example, in situation when payment should be made to a landlord. For those cases, of course, when you're facing periodic payments and it's not a one-shot payment, it's basically a possibility to use a possibility provided by the Russian law on notary activities, allowing to make payments via notary. So how this mechanism is working is that the company is approaching a notary. It's working with a notary, opening a deposit with a notary, and then the notary is making a payment to a particular, counterparty, provided it is able to present certain documents. So as you can see, so the mechanism to a certain extent is very much similar how a letter of credits are working. So that said, there are other possibilities, and there are other options how this might be still handled, although of course it's not as simple as it used to be in the past. Another complication we see our clients are facing, it's a question of trapped cash. Next slide, please. Because we've discussed, there are limitations right now on making dividend payments, license fees, and loan payments, right? There are those limitations and even restrictions, as in case with license fees. It's very difficult to take cash out of Russia. And basically, we see a lot of companies are facing it. Moreover, the local managers are in an uncomfortable situation when they have excessive cash on their bank accounts. So, what are the possibilities here that companies might be considering? Sale of company might be a good option, provided you're considering exiting from the Russian market. And in that case, of course, the amount of cash on the local accounts might be, included into the selling price. By the way, we also see like when companies are getting approvals from Russian companies, of course, for the largest companies that are exiting the market, they're insisting, the Russian authorities are insisting necessarily there should be some discount. That's a very important thing, by the way. Another possibility is making some set-offs, and this is what our clients are widely exploring. Russian loan currency control, specifically Section 19, basically allows making set-offs only in certain specific cases. So it's not, I would say, an easy thing to do, but it's doable. And then, provided there are some undischarged obligations, there is a possibility to make a set-off. And then other possibility normally used for tax purposes, it's so-called debt to equity conversion. When the shareholder is converting its receivables into equity in a particular company, but this option, of course, is subject to certain limitations. If a company is going to exit the market, probably it's something not the most interesting one. However, that would still allow to sell the company, right? Thus inflating the equity's value. KYC, of course, and here we're going to the next section. KYC procedures in new reality. Of course, in those turbulent times when there are designations made by different jurisdictions almost every week, an important role is to screen, right? To screen counterparties. We had other complication that probably went away. I very much hope this problem will go away, because there were discussions that there will be criminal liability for compliance with Western sanctions. And then screening, I think, of course, might be interpreted in a way that this is a part, right? So, but the idea right now is that this draft bill wouldn't be further considered by the parliament. But just a few months, a week, even a few weeks ago, there were like very hot discussions on that. But what is the problem with screening? First of all, of course, how often those sanctions are introduced, and that's of course a lot of efforts would need to be engaged. Another point is that there are different rules, right, applied, and then from Russian standpoint, there will be a necessity to establish whether or not there is control. Of course, it's a category of the UK and the EU sanctions, but here you will need to look basically on how control is determined if we're looking on the Russian part of the structure from Russian perspective. And we see that the Russian businesses are actively reorganizing its shareholding structures using basically new forms such as investment funds, closed investment funds, personal funds. That's a new vehicle that was basically the possibility of establishing those entities was provided only at the beginning of March, and the possibility for example to use fiduciary management companies, whether this would be viewed as control or not. Moreover, of course, the companies are closing their shareholding structures, so there are lots of situations when this information is not disclosed, and it might be let's say, not very easy to identify the identity of the ultimate beneficiary owner and thus establish the sanction status of a counterparty. Of course, in this regard, companies may still use the market knowledge, the publicly available resources, official registers, websites, publications made by different media, and of course, contact the counterparties and request them to provide relevant shareholders agreement, charters, and all needed documentation to establish whether or not a party is designated or not. In certain cases, honestly speaking, there could be pushback. So I wouldn't say it's something that that is really easy to do. Lots of complications there, and I would really like to attract your attention, going to the very last slide of my presentation, is establishment of this control element. Because as you know, UK and the EU introduced special clarifications. The clarifications are very broad, and basically when our clients are approaching us and we have a possibility to review relevant charter documentation and shareholders agreements, that's very, I would say, difficult using the terminology of the Russian law to fully, let's say, establish whether or not those criteria set up in the guidelines in the EU and UK basically are let's say, observed or not. So that's why, like, it's a classic problem for a correlation between different legal systems. But in this specific situation, some solutions would need to be found. And I think your compliance teams and basically you will be able to do so. With that, I think I'm just coming to the very end of my part of presentation. And with that, over to Alexander, and Alexander will discuss with you the problems, contractual problems, the issues related to ongoing courts, and what are the trends there, what are the complications. With that, Sasha, over to you.
Thank you, Vladimir. It's good to be a part of this conversation. These are definitely busy days for our dispute resolution practice. However, for very unfortunate reasons, these are mostly contract suspension, contract termination, contractual liability, and so on. But I'd like to share some hot topics our clients are facing nowadays. And the first of all, that's the question of applicable law. It's not that straightforward as it used to be, because now there are several instruments, to ignore the governing law clauses, the arbitration clauses, and there's definitely a conflict between the applicable law provisions, because Russian authorities do not recognize the legitimacy of foreign sanctions imposed against Russia. And as a result, if a foreign company or even a Russian company terminates or suspends a contract due to sanctions, there may be several problems. First of all, as Vladimir already mentioned, there's a theoretical risk of criminal liability for the local management, which sits in Russia. The draft law is postponed, we believe, till the autumn session of the lower house of parliament, but still there's a risk. So we suggest several risk mitigators here. First of all, switching the decision making to the shareholder level, and shareholders should be based outside Russia. Of course, a court dispute is possible. That's a very painful topic for Russian authorities. And there's a very high risk that a court in Russia will rule in favor of the Russian entity if the contract termination and suspension is related to restrictive measures imposed against Russia. Therefore, our general recommendation is to refer to general commercial grounds. For example, quite a lot of companies are now facing difficulties with logistics, lack of spare parts and so on. And such grounds are accepted quite well by the government officials, by the commercial parties, and so on. And of course, there's an exception to that rule, because if there are some unique equipment products, for example, which cannot be supplied to Russia due to sanctions, such reference is also possible. And another difficulty with referring to sanctions is that such reference is a direct ground to refer the dispute to the Russian court, even if there's an arbitration clause with your agreement. I'll talk about that later. Next slide, please. Lots of questions we have on suspension and termination of contracts, and I'd like to make a couple of comments on some most widely used options for suspension and termination. First of all, it's force majeure. A concept of force majeure in Russia is quite limited. It basically provides for the possibility to ask for release from liability in case of force majeure circumstances. So such circumstances do not automatically lead to termination of contract. Starting from 2014, we've been seeing more and more contracts which refer to sanctions as force majeure circumstances, but the situation is of course heavily dependent on what is written in a specific agreement. So it's really contract dependent. Another difficulty here is that a lot of contracts provide for a special procedure for proving the existence of force majeure circumstances, and it's really difficult now to get such a confirmation for example, from the trade chambers, which are kind of reluctant to issue such confirmation in quite a lot of situations. Here, I'd like to hand over to Teresa for comments on force majeure perspective in terms of the US law.
Yes, thank you, Alex. And we wanted to step in here for just a second to compare and contrast what the Russian law of force majeure is compared to that in the US. Many of you certainly have probably reviewed your force majeure clauses, especially coming out of the COVID-19 pandemic or at the beginning of the pandemic. And we find ourselves now looking at those clauses yet again for this current context. It sounds like a lot of the US law is similar to that of Russia, although it is a bit more formal in terms of how the law is applied in different states. It's generally looked at in the US as a matter of contract law, however. And so the first step is certainly to look at any agreement that you have to determine whether force majeure is provided by the parties as a way to exit a contract. But the benefit, of course, is that if you do have such a clause or the opportunity to raise it as an argument, it could either suspend performance for a certain amount of time or potentially allow for a complete exit of all obligations under a contract and avoid liability for doing so. The other points I just wanted to raise when you do go back to the contract and look at your force majeure clauses that are governed by US law, there are generally two types. So one is called an open clause, and that may be familiar to you because they have generally a description of a type of event based on the impact of the event, whether it makes the performance impracticable or impossible, and generally then provide some objective criteria for determining what types of events may fit into that class. And that is in contrast to another type of clause, which we refer to as a closed clause, where your contracts might actually provide very specific events. And in those situations, if this current context does not fit within the description of the clause, then you may have a more difficult time relying on force majeure to get out of contracts in this way. But thank you, Alex. Those are the points I wanted to raise with force majeure for those that are watching who may be looking at contracts governed by US law. So I'll turn it back to you for the rest of this discussion.
Thank you very much. The next option we can use is unilateral termination. In Russia, it's quite common to have contracts concluded for a specific period of time. And we see some examples where the contract is about to expire, which is a good reason for the party to decline prolongation of the contract if it is no longer willing to perform its obligations. There are some options under Russian law to unilaterally terminate the contract in case of the other party's default. One example being the supply agreements, where if the buyer repeatedly fails to timely pay for the goods supplied, there's an option for the seller to terminate that agreement, and we actually use that option in a couple of cases quite recently. And there may be also specific clauses in a particular contract. Therefore, that's the next step to check if termination is possible. In cases where you don't have enough contractual or grounds determined by the law, there's also a concept of frustration of contract. I should say that the standards for proof are very high in Russia. First of all, there has to be an objective impossibility to perform, to be proved, which means effectively that not only the party to the agreement is unable to perform the obligation, but the other parties cannot also perform that obligation. And the circumstances which lead to frustration of the contract should be of permanent nature, which is really difficult to prove in many circumstances. For example, if we talk about the restrictive measures, quite a lot of legislation on sanctions is adopted for only a limited period of time while being prolonged if necessary. So that's also the question, how that would be perceived by the courts. We have several cases where we refer to frustration of contract, and we'll see in a couple of months whether the courts are receptive to such arguments or not really. When it comes to suspension and termination of contracts, there are also things that go beyond purely contractual relations of the parties. For example, there are companies with a dominant position in the market, and they cannot exit their agreement simply because of their right under law or agreement. There has to be business justification, otherwise that may be considered as violation of anti-monopoly laws. What we also see in practice is that there's a huge number of claims for specific performance, both from commercial parties and consumers, and claimants heavily rely on interim measures, and courts really tend to grant more and more interim measures as compared to the situation before the crisis. And what is also interesting is that in many cases, court award an restraint, the so-called court penalty for failure to comply with the court decision. And in some cases, such a penalty is a percentage of revenue. So it may be really, really high burden for a company to cope with that, with such a court decision. Next slide, please. I'd like to say a couple of words about the employment disputes, because definitely the situation concerns a lot of employees. We basically here have to make options in terms of employee relations. We see a lot of relocations. That's an option for IT companies. Some of them relocated or are in process of relocation of most of their teams. However, other sectors are also relocating their key people to other jurisdictions. Dismissals, there are no changes to the laws in terms of the grounds to dismiss the employees, with the most popular still being mutual termination, redundancy, and liquidation. In the current circumstances, we strongly advise clients to always terminate employment by mutual agreement. First of all, that helps you to decrease the risk of potential government intervention and also the risk of disputes, court disputes with the employees. In terms of government intervention, there were fears that if the company announces exit from Russian market or dismisses people, government will be taking over or impeding the process. But up until now, we don't see any major government intervention. So you may expect questions from the Labor Inspectorate, Prosecutor's Office, on what's going on, what would be the next steps. But if there's a proper explanation of the reasons behind downsizing, that should go quite smooth. What is important is to be careful also with communications, whether internal or external, and especially where you tell employees, because the other day, the reasons you explain maybe with the media. So yeah, you would need to be very careful with that. And also important to note that there's a pro-employee approach of the courts, which is not related to current situation. It's been for 3 years when courts started to seek for any reason to cancel the dismissal and reinstate employee at work. Therefore, that's another reason why mutual terminations are an option in the current situation. And moving to the final part of my presentation, that's Lugovoy law. You probably heard of that law, which provides for exclusive jurisdiction of Russian courts in disputes involving sanctioned parties and disputes the reasons for which are restrictive measures. Another option provided for this Lugovoy law is anti-suit injunction, which may be awarded by the Russian court at the request of the sanctioned party. We see the law has been effective for some time. We see different trends here. Just a couple of examples I'd like to make. The first one is actually the approach to respect the arbitration clauses, because we've seen some attempts to refer disputes to Russian courts even if the party is not sanctioned. And up until now, courts adhere to a strict interpretation of the law, saying that this option is only available to parties which are subject to restrictive measures. Another trend is a bit negative. There was a recent Supreme Court ruling in which the court decided that there's no need to confirm that the sanctioned party is actually struggling to pursue its case, for example, in international arbitration. So the only fact of the party to the dispute being sanctioned is enough to refer the case to the Russian court. There's also a couple of laws which draft laws, which seek to extend the application of the scope of the Lugovoy law. One provides for exclusive jurisdiction in case of a dispute with the party which contributed to adoption of restrictive measures or received unreasonable advantage from sanctions or did not fulfill its obligations due to sanctions. And the second draft law merely provides for the exclusive jurisdiction of Russian courts for disputes with the parties from unfriendly states. As you can see, these are very broad grounds for jurisdiction of the Russian courts. The business community strongly opposes them. Hope we'll see those draft laws seriously revised or not adopted at all, but we'll see in the autumn session whether this happens or not. So the basic recommendations here is to provide for arbitration clauses in sanction neutral jurisdictions. Before February this year, we had two, Singapore and Hong Kong. Now Singapore joined anti-Russian sanctions, so it's mainly Hong Kong. Given the application of Lugovoy law and the incentives to expand its scope, that's not a guarantee at all. Therefore, it is necessary to provide for obligation of the parties to respect the arbitration clauses and to provide ways to enforce this obligation, preferably with the countries outside of Russia where you can enforce those measures. And another topic we move on is, of course, enforcement of the judgments, for example, rendered by the Russian courts. And now I'd like to hand over to Teresa. Over to you.
Thank you, Alex. And in the context of the Lugovoy law that might provide jurisdiction in a foreign court in Russia rather than enforce the parties' contractual clauses to venue, we did want to touch on the question of whether those judgments would be enforced by a U.S. court, because the basic premise is a foreign judgment itself cannot be enforced in the U.S. unless it is first recognized by a U.S. court. And you spoke a bit about international arbitration awards. It's actually much easier in the United States to enforce an arbitration award given the US's agreement to the UN Convention on the recognition and enforcement of foreign arbitral awards, or what we refer to as the New York Convention. But with respect to Russian court judgments and enforceability, this is really going to come down to a question for state or federal courts. And if the federal courts have jurisdiction over the question of enforceability, they're going to apply the law of the state in which they sit, just as they would in any other matter involving diversity jurisdiction. The general idea in the US courts, which is very similar to most courts worldwide, is that they will strive to avoid relitigating issues on the merits. But based on jurisprudence from the Supreme Court, generally speaking, the idea of comity or recognition or reciprocity of foreign court judgments is balanced against the need to protect US citizens and US entities in generally the administration of justice. And the Supreme Court's jurisprudence was attempted to be codified in what is called the Uniform Foreign Country Money Judgments Recognition Act. That model act stems from 1962, and between 1962 and when the model act was updated in 2005, many states have adopted it into their substantive law, although not all have. But the Model Act does provide some specific points in terms of kind of the minimum requirements for enforcement of a foreign court judgment, and also discretionary grounds for courts to decide not to enforce a foreign court judgment. So if we look at first some of the elements that are basically the minimum requirements under the Model Act, the judgment must be final, conclusive, and enforceable under the foreign law. So it can't be a court proceeding in Russia. It must have come to a final judgment to the point of being enforceable in that jurisdiction. The US courts will also look at whether the Russian court had personal and subject matter jurisdiction over the defendant, and also whether the defendant was provided proper notice. Conversely, if we're talking about the discretionary grounds in which a US court may decide not to enforce a Russian court judgment, of course, the courts would look at whether the defendant was not only not provided proper notice in terms of timing, but also whether the basic concepts of due process were provided so that the defendant had the opportunity and was able to defend itself in the court proceeding. Another element is whether the judgment was rendered in circumstances that raise substantial doubt about the integrity of the rendering court with respect to the judgment, and whether the tribunal can be seen as impartial. Alex spoke about previously that in most situations that we are talking about today, we might expect that the Russian court is going to favor the Russian party in the dispute. So this factor may be applicable when later trying enforcing those judgments in the US. Another important element would be if the proceeding in the foreign court was contrary to the agreement between the parties as to where the dispute in question would be litigated. And certainly this element could be raised with respect to whether the Lugovoy law required or ignored the parties' agreement to adjudicate their disputes in an international arbitration tribunal or in a court in the US. So I think we will see the law develop more fully as these judgments are attempted to be enforced in the US courts. So lastly, I will just say that certainly if the foreign judgments are awards for a set amount of money, generally speaking in the US, that is an easier judgment to enforce, but courts will look at whether the award was penal or punitive in nature and tend not to enforce those types of awards against US parties. And then last but not least, courts will not enforce a contract that is illegal under the sanctions laws. So that would be another grounds to challenge the enforcement of a foreign judgment. With that, John, I will turn it back to you.
A couple of questions, if we may. First, this I guess is for you, Vladimir. The questioner is asking, have any companies actually experienced Russian pushback where they're seeking to liquidate the Russian entities or wind down operations, or has this simply been an implied threat to Western companies that may be looking to withdraw or liquidate?
Yeah, thank you, John, and thank you for raising this question. There is very little time that passed, to be honest, just to make an observation here and confirm that indeed this instrument, I mean, the threat of some audits, whatever was used by the authorities. I think we will need just more time to be able to make such a statement. I can confirm that some of my clients right now are facing audits, tax and customs audits. To be honest, very difficult to say whether that's anyhow linked to the fact that companies announced on their exit from the Russian market, or that happened naturally, just because from my side that will be speculation. I'm not aware of these facts. So then I'm very sorry for just providing too many details, but answering directly on this question, I would say there is a possibility, of course, that tax authorities might be looking, on those companies leaving the market from the other angle compared to what they did in the past. That's point two. Point one, point two is that, well, right now I cannot confirm so far that the authorities are acting somehow with prejudice, whatever.
Well, thank you, Vladimir. A second question or set of questions that we have goes to intellectual property rights, where we have a company based in the United States, based in Europe, for example, that has intellectual property rights or intellectual property rights agreements with Russian counterparts. They may be registered rights, patents and trademarks and so forth in the Russian Federation, may be licensing agreements with a Russian partner, licensing the right to use those intellectual property rights. Questions that come up then are, if a company shuts down operations in Russia, are its intellectual property rights, particularly trademarks, at risk of being lost for non-use under Russian laws? Secondly, if a company, especially a company in an unfriendly state, has a licensing or franchising agreement with a Russian partner, have there been developments that would effectively impair or prohibit the Russian partner from paying the contractual license or franchise fees to the foreign intellectual property rights owner?
Thank you. The Russian currency control limitations require that all license fees payable to a licensor from an unfriendly state must be deposited in a special account called O. And then those funds could be released from that special account, provided there is permission granted by the governmental commission, right, so authorizing the release of those funds. And I think our clients, of course, are facing those issues and where they are not able to receive license fees. However, that limitation is established until the end of the year. Well, it might be very well that it could be extended for some time. We hope it won't. But again, just because we're dealing on a day-to-day basis with a number of US headquartered franchisees, we see franchisors, we see that the main issue now is more with a ban on services, right, established by the US authorities, which basically prohibits the US-based companies provide technical assistance and other services under the franchising agreements, right? I mean, not only the transfer of the IP rights, right, but something else, right? Technology is needed, for example, to run local stores and things like that. So we see like there are complications really from both ends, right? So I think it's really very difficult, if not even more than this, for companies to run their franchising business in Russia. And answering your very first question on the threats to IP rights in case companies are leaving the market and they're not using their IP, to which extent kind of they can lose their trademarks. Well, that's a very complicated question because indeed the IP rights they're protected unless they're used, right? And there should be some sort of justification of the fact that relevant IP rights are used effectively, right, of this particular class and purpose. And I believe like so far there are no precedents, and we're more speaking about an opportunity what may happen. I believe in any way, so it will take several years, so the trademark shouldn't be used for several years. But theoretically speaking, I would say, of course, it's possible. However, I doubt that any, let's say, serious company, right, will be really using such opportunities if we're saying about Russian companies. And then in any way, even if someone will try to use a trademark, right, using the opportunity that some company left the market, of course, it may only use such a trademark on the territory of Russia, right? And in any way, so it will need likely to prove the fact that the trademark wasn't used, and then again, subject to the general license that was granted, authorizing the US companies to protect its IP rights. So they will end up highly likely in the courtroom, and then the Russian company or individual will need to prove that the trademark was not used. So I will really say, yeah, theoretically it's possible, but I believe there will be lots of complications, and really unlikely Russian courts will favor this particular type of disputes. I mean, they will not, in my view, unlikely they will rule out in favor of Russian companies and Russian individuals.
Well, following up on that, then, Vladimir, do you have any, it may just be speculation at this point, but any thoughts on how likely it would be that a trademark or IP owner would be able to get effective remedies in the Russian courts if a third party were to start using its trademarks or other IP?
That's a great point. And of course, this is something where we'll need support of our IP attorneys just to advise on, let's say, ideas that might be used, first of all, to confirm that the IP right is indeed used, right, and it's properly protected. One of the things that is popping up in my mind is a possibility, for example, to use the register that is with the Russian customs authorities, right, that are looking on the possibility to import products to Russia that are protected. Of course, indeed, right now, we also see there are new regulations authorizing so-called parallel importation, right, in case the IP holder doesn't supply or doesn't authorize the supply of original products to the Russian market. But I would say still the fact that the IP holder might be, coordinating its activities with this register might be, a proof, let's say, that's the IP owner is still, enforcing its rights, and the IP right is still used in Russia. Moreover, again, it's not prohibited to grant IP licenses, right, to some Russian counterparties. If it's granted to someone, then I would say this is a direct confirmation of the fact that the trademark is really used. And then again, that will be another argument to claim that the trademark is used and no one can basically use an opportunity that's basically the company itself left the market, but still, for example, it has some license agreement with local counterparty. But this is like, I would say, a very preliminary ideas on what basically might be done to try to protect IP holders. But I would say, yeah, indeed, that might be a separate topic for a separate discussion, which won't be an easy one.
Oh, thank you, Vladimir. One question, I guess, for both Alex and Teresa, with respect to your discussion of force majeure. I wonder if you could comment on perhaps a more robustly drafted force majeure clause that would refer either to excuse of performance due to legal and regulatory developments generally, or even more specifically, if performance by the contracting party is prohibited or impaired by applicable export controls and or sanctions laws. And Alex, particularly to you, the question of how that might be received in a Russian court, given Russia's view about the legality of sanctions generally.
Thank you, John. Yeah, I'd say that it's definitely necessary to mention in the contracts that restrictive measures will be considered by the parties as force majeure circumstances. Another aspect is that in quite a lot of cases, that's really case specific. For example, if you have proper wording in a contract, but failure to perform obligations is not really related to sanctions, restriction measures, or whatever, the court will most likely rule against that party which is in breach of its obligations. We did a review recently of the case law regarding sanctions as force majeure, and I would say the split is 50-50. So it's really case specific. For example, if you cannot take unique spare parts for your production, that's a good excuse for failure to perform. But if that's not related, then you can buy those spare parts in Russia, for example. That wouldn't be a valid reason.
I can add to that, John, just by saying that most courts in the US are going to take a very narrow reading of a contractual force majeure clause. So in order to make one more robust, certainly when I spoke about the difference between an open clause and a closed clause, the parties would likely want to use a closed clause where sanctions or unexpected government action, war, those types of events are expressly listed in the clause as examples of events. The other point I would make is that while the contractual clause itself might expressly cover the situation, there are some states where, in addition to just proving that the event falls within the force majeure clause, the parties would also be required to show that they actually made efforts to find an alternative way to perform. And that might present another hurdle to some parties in this instance. But to Alex's point, if we're talking about the inability to provide supplies or obtain supplies or provide labor, those elements might also be at play in showing that that generally performance or an alternative performance simply wasn't possible for one or both of the parties.
Thank you, Teresa. Well, thank you all to Vladimir, Teresa, and Alex for your contributions. A great program, and obviously a lot of food for thought for all of us as companies struggle with these rules in terms of how they may apply to their contractual as well as their operational issues within Russia, including withdrawing or shutting down. So there's really a lot of food for thought there. And as Vladimir indicated, that it's all very much a moving target, both in terms of interpretation of the rules that exist and the possibility, of course, that there will be further developments, either judicial or regulatory, that will affect the operations in Russia in form of countermeasures. So counterpoint between the concepts that we discussed in the earlier program and the concepts presented by Vladimir and Alex today. A lot to keep in mind as you're trying to discharge responsibilities for compliance in dealing in the Russian environment. Well, that brings us to the end of this session. Again, thanks to everybody for joining us here this afternoon or this evening for the program. This is the 5th of our 6 programs, and we do hope that you'll be able to join us at our concluding program, which will be happening in about 2 hours. In the meantime, as you log off of the webinar, you will be presented with a comment or evaluation sheet. Please do provide us with your comments. We find it very, very helpful in terms of that kind of feedback and in developing programs in the future that are as responsive as possible to everybody's needs. So with thanks to all of you for attending, with thanks to Teresa, Alex, and Vladimir, and a special thanks to our team of Liz and Anna for all their great administrative and logistic support. See you in a couple of hours. Bye.